Good morning, everybody. Thanks so much for joining us this Tuesday for our series of Secrets of Successful Retirement. Today's topic, we are going to be covering critical legal documents. We also have a guest speaker, our attorney, Andrew Friedman, that will be speaking on this particular topic. But as for us as Senior Resource Center, we help in 4 specific ways. We do comprehensive retirement planning, looking at long-term planning to make sure you don't outlive your money. We do tax planning to help you pay less tax. That's not tax prep. It's just finding ways to pay less tax over your retirement. We do extensive long-term care planning, including insurance products and helping people qualify and protect money with federal and state programs to cover long-term care, and then estate planning, just making sure you have the right legal documents in place. And that's specifically what we're covering today. So if you missed any of our webinars starting back in February, they're always available on our website under resources. You can always go back, click on the words, and the link will pop up and a nice video will show. You're welcome to review those anytime you like, pass them on to a friend or family. So after today, critical legal documents that we'll be covering today, next week is Income Changes Everything, which is really important, just how you can maximize your income in retirement so that you can enjoy your lifestyle. All right, I'm going to turn it over to Bill.
Thanks, Tara. Hey, welcome everybody, and glad you joined us today. Today's one of my favorite webinars because I get to delegate this to one of our trusted affiliates, Andy Friedman. Before I go into this, just want to, kind of give our general disclaimer. Everyone's situation is unique. Your situation is unique. And so the legal documents you need will be specific to your situation. Tara and I are not attorneys. So we always tell our clients, refer all legal questions to a licensed attorney. And it's been our good fortune to work with Andy Friedman for, I think, going on 18 years, maybe longer. In fact, the reason we're in the building we're in is because this is where Andy has officed, and we used to office somewhere else, but we moved here so that we could be closer and make it easier to refer clients to Andy for legal questions. And with that, let me introduce the man that I believe is one of the top elder law attorneys in the state of Texas, Andy Friedman.
Thank you, Bill. This is Andy Friedman, as Bill just said, and I'm going to be talking today. I think the title was Critical Legal Documents, and an overarching theme to this is these documents taken together constitute your estate plan. So, and I'm not certain why I titled this The Problem, but nonetheless, estate planning is how you provide for you, yourself, and your loved ones, protect your wishes, direct how your property is used while you're alive, and then again, who gets it after your death. Now, the concern, I guess this is the reason for the title, the problem is if you don't use the right legal tools, that can frustrate these goals and generate some unnecessary expenses and stress. So how do we break these documents down? I do it basically twofold. Most lawyers will break things in two, no matter what you ask them. In my case, it's estate planning documents that apply while you're still alive, and then secondly, the ones that apply at death. And this is kind of the reverse of what most people have in mind. If you think of estate planning to the extent you think of it at all, it's usually, I need a will. Well, a will is a very important document. We will get to it in a little bit. But the important thing to remember is it only applies when you're gone. So just by definition, it's less interesting. It's who gets your stuff. What happens during your life is, to my way of thinking, a whole lot more interesting. Let's see, change slide. Okay, estate planning overview. There's, as I said before, 2 categories. There's actually 3 to think about in terms of how the estate plan works over your life. There are 3 stages of life, if you will. The first is while you're alive and fully competent. And in that situation, it doesn't really matter what kind of estate plan you have because it's just you. The second one is if you were to become incapacitated. And this, I mean, some form of disability that stops you from being fully in charge and taking care of yourself and your property and your loved ones. And the third is the stage, as happens to all of us. At some point, you will die. And then the estate plan kicks in to divide up your assets and appoint someone to act in your stead until such time as the property has been distributed. There are three alternate estate planning approaches. One is the default, one is a will-based plan, and one is a living trust-based plan. Now let's start with the default. And the reason I'm starting with this, there's a couple. The first is I want you scared of it. When you think of the default, this is what happens if you don't do anything. Then the state has created an estate plan for you. It's broken into two categories. What happens to you while you're under some form of disability, and then again, what happens to your property after your death. Sorry, I lost my place there just for a second. I guess I was talking a bit too fast to think. But the two kinds of default estate plans during your lifetime while you're incapacitated, that's referred to as guardianship. This is a court overseen process. And then at your death, the process for distributing your property is referred to very broadly as intestacy, or in Texas, it's governed by the law of descent and distribution. What are your alternatives? If you want to plan for your estate, you don't want to rely on the court overseen process, then you have the option of meeting with an attorney or working yourself to design how this property should pass, how it should be used for your benefit while you're alive, for your benefit, for the benefit of your family and loved ones, and again, what should happen in the case of your incapacity, and then again after death. In a very broad sense, there's essentially 7 or 8 documents that'll cover this. During your lifetime, there is what's, again, generally referred to as a financial power of attorney. In Texas, it's called the statutory durable power of attorney. Second, the medical power of attorney. Third is the living will. Again, in Texas, the term is directive to physicians, and in some places it's referred to as an advance directive. Then there's a HIPAA authorization, a designation of guardian either for yourself in the event of incapacity in the future or for your children or dependents, and then a trust. After death, there are 3 other documents, one overlapping. One is a last will and testament. Second is, again, a trust. And the third is using beneficiary designations. And this is not so much a legal document as a contract you enter into in dealing with different financial institutions. Let's go to the big one. What is the financial power of attorney? And again, in Texas, it's referred to as a statutory durable power of attorney. Statutory because it's created by a statute passed by the Texas legislature. Durable meaning it continues beyond any incapacity that you may suffer. So it doesn't stop simply because you become disabled. What does it do? Well, the first and most important thing is it names people to act for you. One or more people to act for you during your lifetime. So again, the distinction here isn't the person appointed under a financial power of attorney, your agent, is not the same person as you appoint as the executor under your will. The dividing line is your death. Power of attorney works up until the point you die, and then it stops working. The will only takes place at death. So you don't have a power of attorney appointed in the will. Those are conceptually opposite. You can decide when this power of attorney takes effect. You can say it becomes effective as soon as the ink dries, or it's triggered by your disability. This should be a durable power. And again, durable, as a reminder, means it continues from the point when you sign it until such time as you die or revoke it, or if a statutory provision kicks in. For example, you become incapacitated and are made a ward of the state, and a guardian is created for your estate, then that would revoke the power of attorney. My suggestion on this document, one of them, is that you do not name multiple co-agents. And again, the person you appoint to act for you is called your agent. Don't appoint more than one person to serve at a time. I strongly suggest you appoint multiple people, but they should serve in order. The main concern driving this is logistical. If you were to name two or more people at the same time, it's distinctly possible that in acting for you and dealing with some third party like a bank, that bank would require both people there at the same time, which quite often is difficult with varying schedules. What is the second document we mentioned? The medical power of attorney. This is just like the financial, except it deals only with medical and healthcare decisions. Once again, you use it to appoint people, that again called agents, to act for you and take a medical decision or a healthcare decision on your behalf for you. This takes effect, the power of attorney, medical power of attorney, takes effect when you are unable to act. So don't ever worry about the fact that you and your agent might disagree. That's not even possible. The only time your agent's authority springs into effect is when you are deemed incompetent to take a medical decision. And I'd go so far as to suggest that basically means you're unconscious. Most of the doctors that I've had as clients that I've asked this, they're always going to ask the patient first. It's only if basically they're in a coma or so heavily medicated that they can't respond that they'll turn to the agent. And that's why it's sometimes referred to as a springing power of attorney. That power to take the medical decision springs from you to your first named agent when you're deemed incapacitated. Now, the form of this document has changed since it became standardized in 1999. It's now possible to have it either witnessed by two people or to have it notarized, which is usually, in my practice at least, far more convenient because I'm a notary. Once again, this is not so much a suggestion as I think it's my interpretation of the law. I don't think you can name co-agents under the law as is drafted now. You have to name people to serve in order. And what this means very clearly is the order you name them is important. You want to choose the most reliable and trustworthy person first, and then the second and the third in the order that you think they should serve. Third of the documents is the living will. And as you recall, there's about 3 different names for this in Texas. It is called a directive to physicians and family or surrogates, sometimes broadly referred to as an advance directive. But I'm going to use the term living will because that's the name that was established in the, I believe, 1972 U.S. Supreme Court case relating to Nancy Cruzan, when the Supreme Court suggested that this might be a useful avenue for people to give guidance to their medical agents and their doctors. What do you do with a living will? Well, the first is you provide guidance to your medical agent and your doctor and say, here is what I would like to happen under certain circumstances. So it does require a lot of careful thought. The document, as the legislature has drafted it, does have 2 decisions you will have to make on the first page. One is referred to as a terminal illness level of care, and terminal illness is defined in the document, and you can play around with that definition, but as a starting point, it's suggested it be you have a 6-month or less prognosis. In other words, your doctors have said, you will live for 6 months and no longer, regardless of what we do. And in that situation, you can in advance say, either give me whatever is necessary to keep my life going, and that's referred to as life-sustaining treatments. Or alternatively, you can say, keep me comfortable, comfort-oriented or palliative care. And it's simply an initial the box. You say, I want comfort care or I want life-sustaining treatment. The second decision on the first page has a very similar answer set, but the frame of reference is different. They say instead of having a terminal illness, you have an irreversible illness. In my mind, this is linked with a situation that many of you may recall from, I guess it was around the turn of the century. Between 1991 and 2005, there was a case relating to a lady in Florida named Terry Ann Shivo, and she went into a coma, I think through a drug interaction, and she stayed in that condition for about 15 years, during which time, for the first 4 or 5 years, it was a private medical matter between her husband, their family, and their doctor, and then there was some money that came back as a result of a lawsuit filed for the cause of her incapacity. And that separated the husband and the family. And they, as most people in America do, went to court to resolve it. And so for the next 10 years, it was playing out in court. And that's why all of us get to know about it. But in essence, she was a fairly healthy, strong individual in her early 20s, and she hadn't signed a living will. The Florida version, I think, was also called a directive. And so her husband had to continue going into court to become her limited purpose guardian for the purpose of making medical decisions. And again, for the first 4 or 5 years, everyone was in agreement. Then the money came back from the lawsuit, and the father of the family and the husband got crossways. And so it played out in the Florida court system. It then made its way into the Florida legislature. Florida governor weighed in. The U.S. Congress and even the U.S. president all decided they had something to say about this. What I'm getting at rather long-windedly here is this document can be extremely important in keeping private matters private. You can not only make those decisions like the Terry Ann Schiavo situation, you can also give guidance, just general guidance to your medical agent saying, if you're making a medical decision on my behalf, here are some things I want you to consider. Here are some things that I don't want you to do, or here are things I really would like you to try. In other words, give them some information so they can make a choice, because you have to assume at the time this document comes into play, you're unable to speak and you can't communicate your thoughts. Once again, as with the medical power of attorney, this can either be notarized or witnessed. Notarized is the favored approach. And again, in Texas, this is called a directive to physicians. Then we come to the post-death documents. The first one is the one most people are familiar with, at least in concept. It's a last will and testament, or a short form, a will. What does this do? Well, this divides your property. First off, it takes effect on your death. So again, it can't do anything while you're alive. A will is simply a piece of paper or several sheets of paper that say, here's where my property goes after death. It has no effect until you die. It names the executor who carries out your wishes, who executes your wishes. The executor's job, broadly, is to gather and manage all of your property, to determine what your creditors are, pay your bills and taxes, and then after those are taken care of, take what's left, the net amount, and distribute it according to the terms in the will, where you say who the beneficiaries are. Crucial point here, because this is a point of some misinformation on the internet at least, a will requires probate to be effective. That's what gives it power. Until it's admitted to probate, it has no power. It doesn't do anything. So what is probate? Very briefly, it's a legal proceeding to transfer title from the assets you own to the people who should get it, and to appoint a personal representative. If you use a will, that personal representative is referred to as an executor. If there is no will, then it's referred to as an administrator. The court, by admitting the will to probate, signing the order that says this will is admitted, gives power and effect to the will. If there is no will, probating your estate requires, again, taking it, your death certificate and application to court, and requesting that the court create an intestate administration. Intestate is basically a lawyer's version of the second word, last will and testament. If there is no testament, you are intestate. Probate is carried out in public, and it only covers probate assets, which may sound somewhat what is it where you say the same thing? Anyway, probate assets are those that are in your own name. I lost that term there. Anyway, if you own property in your name or in your name along with someone else's, whether it's totally owned or a portion or just an interest, that is probate property, and therefore it's covered by a probate proceeding. There are a lot of property that is not covered by probate, primarily because there are contracts governing how it should pass on. A very simple example is when you have a bank account and you have a provision that says pay on death, or POD. That's a contract with the bank. At death, notification of death with a death certificate, the bank will pay that money to the named beneficiary. It doesn't pass through your estate. It doesn't get controlled by your will, so it's a non-probate asset. There's variations on that. POD, TOD. There's a way to hold property with someone else where by contract it passes to the survivor. This is called a joint tenancy with rights of survivorship. Those are also non-probate assets because they're not controlled by the will. Then you can have a beneficiary designation, most often used in a life insurance or retirement plan, where you simply name the person who gets the property. So it's very similar to POD. That also is a contract that takes it outside of probate, so your will has no effect on it, and it's not a probate asset. And then a very popular alternative is to set up what's called a revocable living trust, which is in essence a contract, and it designates who the beneficiaries are after your death, and sometimes during your life as well. And so that also is a non-probate asset. So really, when you consider what the will controls, it's primarily a house, accounts that do not have beneficiaries named on it, or joint tenants who co-own it with you. So it's a far smaller percentage of your overarching estate than you might otherwise consider. And we come to trusts. My practice is very heavily focused on the use of trusts, but not necessarily that trust I was focused on earlier, the revocable living trust. I do some of those. Maybe about 30 to 40% of my clients base their legal estate plans on a living trust. But to be clear, the last time one of my colleagues did a survey, there were 65 different kinds of trust. So just using the word trust itself doesn't define it too well. However, I can give you its attributes. First off, a trust is not an entity. It's not a corporation or an LLC or a partnership. A trust is instead a relationship between three people that the law recognizes. Those three people are called the trust maker, the trustee, and the beneficiary. The trust maker is the person who makes the trust and puts property into it. The trustee is the one who administers it, and in the eyes of the law is the legal title holder, the owner of the property. And the beneficiary is the one who benefits from this relationship. Property that's held in a trust name is not subject to probate. It's effective upon signing for all the property that is titled in the name of the trust. And that means it has two benefits that are worth focusing on. The one commonly used is avoiding probate. And again, in Texas, I didn't go over this too much, but probate is a fairly simple process. It's not without a time outlay, and it's not without cost, but it's nowhere near as concerning and something to be avoided as it is in, say, California, where it's the costs associated with it and the time are both a measurable portion of your estate itself and a fairly lengthy time outlay. In Texas, it's a fairly straightforward proceeding, which, again, with a well-drafted will, can be wound up in about a month or so. But going back to the trust, if you set up your property and hold it in a trust name, it doesn't pass through probate. And that means not only after death, but earlier when I mentioned guardianship and guardianship of the estate, that's the disability plan when you don't have documents in place. That's when the court takes control of your property. And a guardianship of the estate can be extremely expensive and last for your entire life from the onset of disability on. And it can run through all of your assets. Property that's held in trust is exempt from that form of probate, called living probate, just as it is exempt from post-death probate. The trust itself is nothing but a series of instructions. It tells your successor trustees what to do with your property for your benefit or the benefit of others while you're incapacitated, and then again, who should benefit from it after your death. It directs how your creditors should be paid, and it distributes the property you have at death, or disability, according to your instructions. So what's the overarching goal of all this? Well, there's a few of them. One is disability planning. And by this, I mean not so much medical concern as a way that you are choosing in advance to plan for how your incapacity should be dealt with. Who should be given, to a large extent, power and directions to help you in your disability? How should your property be used during that term of incapacity? Who should benefit from it? Um, a large number of instructions can be incorporated into your existing estate plan. If you are married or you have children who are minors, you want to make sure your estate plan deals with them. You should leave instructions for how your successor, whether it's an agent under a power of attorney or a successor trustee under a trust, how they should use your property to help support the life of your spouse and your minor children. If there's blended families, and by that I mean suppose you have a second marriage, you or your spouse is in a second marriage, that's two different families. You want to make sure as much as possible you make clear what you would like done with your property in the event that you can't do so yourself to take care of your family and the family that you're married into. Asset protection. This is one of the main focuses of my practice, is trying to keep your property in such a way, titled, held, and protected, that it doesn't get taken from you. Catastrophic illness planning. If something bad happens to you in an illness sense, what do you want to happen? You have to think about this and decide how you would like to respond. Retirement planning. All of us, at least in theory, are going to be looking at that blissful day in the future when we're not working for a living, but the property that you have is then static and you have to direct how it's used. Promoting your own values, especially if you have a family and you want to direct people or give guidance and make suggestions about how they should act. You can promote those values using your property, and you can write down instructions so your successors can continue to do so. Social legacies in the form of charitable intent. If you support a charity, whether it be social or religious, you can leave property to them. You can give property to them during your lifetime. As long as you leave instructions for your agent to continue doing so, it doesn't matter whether you're able to do it yourself or not. And then perhaps not the last, but certainly the last I'm going to mention is saving taxes. You can plan to minimize your taxes. There's I think it was a Second Circuit Court judge referred to, his name was Learned Hand, and the quote most often attributed to him is, "Everyone is required to pay the taxes they're owed. No one is required to pay 1 penny more." So if you stay within the law and you minimize your taxes, you are doing exactly what you should do. And your plans in your estate plan can help affect that. All right, that's it for my rambling presentation. If you all have any questions.
Andy, thank you. Really appreciate your guidance and expertise today. Tara, tell the people about how they can submit questions if they have any.
Yeah, if you have any questions, there should be a blue talk bubble at the top of your screen, and you can go ahead and type those in now. We're happy to answer any questions. If you want to answer questions offline, you're welcome to call us or Andy specifically for law-related questions, and our information's on the screen, phone numbers and email addresses.
Yeah, one thing that, Tara, I think is important, Tara and I have always believed in the concept of free consultations. You know, if people want to come in and ask questions, we shouldn't be running a meter, and Andy has that same philosophy. One question I've got, Andy, a lot of times people are asking me, what is the cost of probate? What does it cost in Texas, and whether I have a will or I don't have a will?
Good question, Bill. There's two components to the cost for probate. One is the costs that you are going to be paying expenses directly to the court costs. So there's filing fees, ancillary documents that have to be filed after the initial application, payments for the judge's signature, and then filing notices in the newspaper. I've sort of blended those all together as court expenses. The second one is the fees that you pay the attorney. Generally speaking, in probate, that's going to be determined on an hourly basis. So it varies rather drastically depending on what you're trying to do in probate. If you have a very well drafted will and it's clear and there's no intended or expected contest by a family member, then it's probably going to run, I don't know, I'm guessing 6 to 8 hours of the attorney's time. If any of those components are missing, for example, there is no will, so you have an intestacy, you can probably double the amount of hours, certainly almost triple the amount of time. If you have, like I said, that's probably a good framework. I didn't want to go into too much detail.
Yeah.
That's good. Over the years, we've worked with many families, and we've seen situations where people die without, or people become disabled or die without the right legal documents. Like, what if I own a home with my spouse, but I don't have powers of attorney, and let's say I become incapacitated, and my spouse wants to downsize or sell the house? What are the challenges?
Well, the problem there is, as you've set it up, is both you and your spouse own the house. And when you sell a house, the title companies will require both owners to sign. If your spouse is incapacitated and has a power of attorney in which he or she has named you as the agent, then you can sign on their behalf. If you have not done so, then you're going to have to seek some form of court intervention, which could get fairly difficult.
And that's, I assume, where maybe guardianship comes in. What kind of costs are we talking about if people don't have a power of attorney and have to maybe go to a court? What kind of costs are involved in guardianship?
Guardianship is considerably more expensive than estate planning or standard probate. At that point, you're paying hourly, and it's much closer to true litigation. You will have attorneys ad litem who represent the unknown heirs and the minor beneficiaries. You also have possibly attorneys representing other family members. This can get contested, and the cost here can dwarf any conceivable estate planning charges.
So I guess the simple answer is get your legal house in order, get the simple documents that you talked about today, like financial power of attorney, medical power of attorney, living will, and so forth. Have those in place, and then you eliminate all these additional costs that would pop up if you haven't planned your estate.
That's exactly right, Bill.
Well, good.
Well, you want to speak into next week's presentation?
Yes. Next week, we're going to cover a topic that is essentially the core of our practice. If you've read my book, and by the way, everybody that's listening, you'll get a free copy, a PDF copy of the book. I wrote it during the pandemic, and it tells you what we do in our practice, the topics that we help with, like Social Security, Medicare. We touch on legal documents, paying less taxes. But the core of our practice, Tara and I years ago took a different path. Most financial advisors today strive for asset growth. And we're not opposed to that. We like asset growth. But because we don't control the market, markets can go up and they can also go down. If you remember 2000 or 2008, people that were in the market got hit pretty significantly. Tara and I have taken a road less traveled, and that road is helping our clients build income in retirement to support lifestyle. And once you have enough income, it doesn't matter whether the market's up or down, whether interest rates are up or down, because you have the ability to pay for your quality of life. And so next week we're going to talk about the power of income, if you will, and how income can change everything, how it can improve your peace of mind and give you confidence that you can spend without running out of money. So put it on the calendar. It's always Tuesdays at 10, and we'll be covering that. And then you saw the schedule. We've got some other very interesting topics coming up in the weeks ahead. So thank you for joining us, and look forward to your involvement and participation next week.